raising your child, you're covering groceries, rent, and school supplies, and yet the other parent, they've contributed nothing. You're frustrated and you're asking, how do I actually get child support started in Illinois? I'm Jeff Hughes, lead attorney at Sterling Lawyers, and we have helped hundreds of Illinois parents secure court-ordered support even when the other parent was uncooperative, unemployed, or outright hiding. In this video, I'll walk you through exactly what to do from filing to enforcing based on Illinois law as of 2025. I'll also share client stories so that you can see what works and what mistakes to avoid. Let's start with step number one. Choose how you will file. Now, there are two paths to do this. Option A is to file online with the Illinois Department of Healthcare and Family Services, HFS. Option B is to file directly in your local circuit court of your county. Now, both are valid. HFS is free and can assist with enforcement, but it often takes longer. Filing in court tends to move faster, especially if you already have a divorce or paternity case that's open. Now, here's a big tip. If you expect pushback or a fight from the other parent, such as income disputes or underemployment, the circuit court filing gives you more direct control over how the case proceeds. An example of that would be a father that we worked with. Now, he filed with HFS, but he waited 9 months for progress. When he switched to a direct circuit court filing with our help, he had a hearing scheduled within 30 days. Step number two, gather the information. Before you file, collect everything that the court or agency will ask for, such as your full contact information, the child's details, the other parent's information, name, address, date of birth, social security number, and employer if you know that. Also, income details for both parents, existing custody orders or divorce judgments, health insurance or special expense documentation. And if you are the custodial parent, you do not need to prove the other parent's failure to pay. But the more organized and thorough that you are, the stronger your case. I recall once a mother came to us after her petition was delayed multiple times. Why? She had incomplete income data on the other parent. We helped her reconstruct the other parent's job history using public records, which let the court impute income and move the case forward. Step number three, file the petition and the correct forms. Now, here's what you will need: a petition for child support, a summons if you are filing in the circuit court, a financial affidavit, and a parenting plan or a custody order if that is applicable in your case. And you can find most of these on the Illinois court website or through your county clerk's office. After filing, you will have to pay a fee, and that's typically around $200 depending on the county. And if you can't afford it, you can ask the county for a fee waiver. By the way, that's Form 2985. Once accepted, the court will schedule your initial hearing, and that usually will occur within a few weeks. Okay, step number four, serving the other parent. Illinois law requires that you formally notify the other parent unless you have filed jointly or they have already appeared in this case. And to serve them, you can do that a number of different ways. You can do it in person. That's usually done by a sheriff or a private process server. You can do it by certified mail. That applies to some cases, not all of them. Or you can do it by special court-approved means if the other parent is avoiding service. Now, if they don't show up and they were properly served, you can still proceed. That is called a default judgment. Step number five, attend the hearing and present your case. At your court hearing, the judge will review both parents' income, the parenting time that both parents have, the physical custody they have with the child, child-related expenses, and health insurance coverage. Illinois uses an income shares model, which considers both parents' combined income and then divides responsibility based on each parent's share of time with the child. Now, in 2025, there has been an important update. If the other parent reports zero income, the court can still impute income to that parent, meaning it will estimate what they should earn based on work history, education, assets, and the local job market. What this does is it prevents intentional unemployment or underemployment from reducing child support unfairly. We once represented a mom whose ex quit his job just before the hearing, and he did it to lower his obligation. But we presented evidence from LinkedIn, past pay stubs, and job listings from his field. And what the judge did was it imputed $65,000 a year in income and set child support accordingly. Step number 6, understand your enforcement options. Once the court enters a child support order, payment becomes a legal obligation. And if the other parent doesn't pay, enforcement options will include wage garnishment, bank account seizure, tax refund interception, license suspension, property liens, and contempt charges, which may lead to jail time. And there has been a major 2025 change. Illinois law no longer adds interest to unpaid support, but enforcement is still strict. Step number 7, know when and how to modify the order, because child support is not set in stone. If income, parenting time, or living arrangements change substantially, you can petition to modify the support amount. Now, some common reasons for that would be job loss or job change, one parent remarries or has another child, custody placement changes, or the child develops special needs. To change the order, you need to file a petition to modify support and be prepared with current income documentation. Step number 8, use temporary support during a divorce if that is applicable in your case. If you're divorcing, you don't have to wait for the final judgment to get child support. Illinois allows temporary support orders during the divorce process, and this protects the child's needs and prevents one parent from being financially squeezed while waiting months for the case to finish. Now, here's a big tip. If you don't have an attorney, use the state services. They're there to help you with this. You do not have to do this alone. There are legal aid or pro bono clinics that can help if you are low income. Illinois HFS website offers filing help, updates to the income schedule, and enforcement services. Or an experienced family law attorney, of course, can help you move your case faster and maximize your support, especially in high conflict or unclear income situations. Now look, child support is just one piece of the puzzle, but what if there's abuse involved or you need protection right away? In our next video, I'll walk you through how to file for a protective order in Illinois and what to do first if domestic violence is part of your story.